That's it. Sarah?
Thanks, Jonathan. I'm Sarah Brown. I practice consumer law at Mountain State Justice, where I've been for about 8 years, focused almost exclusively on mortgage cases. Every once in a while, Dan makes me take a car case, and I moan and complain about it. So I focus on mortgages, and that's what I want to talk to you about today. It's just a very specific and particular area that we see happening, I think, more often in West Virginia than maybe in other places, and that's the issue of successors in interest. So if the borrower on a loan either passes away or goes through a divorce, who then takes over the ownership interest in that property, and what happens with the mortgage. There's also been some recent federal changes after the Dodd-Frank and CFPB rulemaking authority about a year ago. Some changes came into effect in this area that I just want to highlight. So mortgages generally are not freely assignable. So most standard deeds of trust, or the security instrument, the mortgage instrument, has a provision that if the property is sold or transferred, that loan can become accelerated and due on sale. That's the common clause. Starting in 1982, under the federal legislation, the Garn-St. Germain Act, mortgage lenders were prohibited from calling the loan due or accelerating it upon transfer in certain limited circumstances related to family transfers. So if the most common situation perhaps is a husband and wife, one spouse is the borrower, but both reside in the home, the spouse that is the borrower dies, the remaining spouse inherits the property, but they weren't on the loan. After 1982, that surviving spouse was permitted to remain in the home and make those payments. But as you can perhaps imagine, there were some difficulties in communicating with that surviving spouse. And because that surviving spouse was not considered a borrower, they didn't have some of the rights and protections that a borrower would have. So starting in 2014, again, the CFPB, under the Dodd-Frank rulemaking ability, required servicers to have policies for how to deal with this situation. The other time it arises a lot is in a divorce. So there might be a divorce order from family court saying, one spouse gives their interest in the property to the other, but if that spouse was the borrower, the bank's not going to recognize that family court order allowing that transfer. So what happens then in terms of the mortgage servicing? So the rules that started went into effect in 2014 simply required that mortgage servicers have a policy for how to deal with this. So once the mortgage servicer learned that there had been a transfer of the property, whether through death or divorce, the loan servicer had to have a policy for how do you communicate with who's called the successor in interest. Those rules became much more detailed and more specific in April of 2018. So just over a year ago, we saw these rules go into effect. There are now a set of objectives that mortgage loan servicers have to follow, not very specific in terms of the timeline or how to implement these objectives, but a servicer is required that once they receive notice of a death of a borrower or any transfer of the property securing a mortgage loan, they must, and I quote here, promptly facilitate communication with any potential or confirmed successor. So we read into this some reasonableness standards about what that promptness might be, but there is a requirement to facilitate communication. A servicer is also, the next objective is, upon receiving notice of the existence of a potential successor in interest, determine the documents that the servicer reasonably requires in order to confirm the identity of the successor in interest and that the person is in fact the successor in interest. And then the servicer is, part 3, obligated to, upon receipt of those documents, promptly make a confirmation determination as to whether this person has been confirmed the successor in interest, and if not, what further documents might be required to make that confirmation. The significance legally of having a successor in interest is that, again, as of just over a year ago, a confirmed successor in interest is considered a borrower under RESPA. That's the Real Estate Servicing Procedures Act. So all the protections that go to borrowers under RESPA now go to a successor in interest once they're confirmed. Perhaps most significantly, that includes things like loss mitigation, applying for a loan modification. That's something that a borrower has certain rights, and very specific rights, about the timeliness and the stages at which a loan modification needs to be offered and reported on. Those same rights now extend to confirmed successors in interest. There's also a definition under TILA, the Truth in Lending Act, that a successor in interest, once confirmed, is considered a consumer. So those are the two definitional changes as of a year ago. We're seeing servicers now implement these policies. The two areas that I think we still continue to see some issues with and expect to continue to see issues with are, first, servicers requiring either repetitive or unreasonable documents in order to confirm a successor in interest. There's some guidance from the CFPB about what is reasonable in order to confirm a successor in interest, but it's tied to the fact specific to that case, and it's also tied to that state. So if you have a married couple and they are on the deed as joint tenants with right of survivorship, and the borrower spouse passes away, the mortgage loan servicer, upon notification of the death of the borrower, needs perhaps a death certificate, something like that. And then if they already have the deed that shows that surviving spouse is the joint tenant with right of survivorship, that's all they need. They can't demand executor documents. They can't demand probate documents. If they have the deed and the deed shows that that surviving spouse has become the successor in interest on that property, that is what is reasonable. And that's one of the specific examples. If a servicer receives a divorce decree that grants that interest in that property, if that's sufficient in state law for the transfer to have been accomplished, that's all the servicer can require. So again, it's tied to what effectuates the property transfer under state law. That's what can be reasonably demanded by the servicer. So we do continue to see, and I think we can expect to continue to see, servicers demanding documents that they might already have, some of the same problems we've seen in the loan modification context: lost documents, missing documents, repeated requests for information, and that may be an area for litigation over what's reasonable to confirm a successor in interest. The other issue is that what causes a transfer of the property are often things that also result in financial hardship, right? So it's a time of divorce, it's a time of loss of income from death. So often the successor in interest is also going to have a financial hardship that might prevent them from paying the mortgage as it stands, or the mortgage may have even fallen behind in the case of illness leading up to a death. So we find that, people often need a loan modification at the same time that they're being named the successor in interest. What's significant is that the rules require a mortgage loan servicer to consider the successor in interest as a borrower, regardless of whether they have assumed the loan or not. So even if the surviving spouse has not signed on the dotted line and said, yes, I'm assuming personal responsibility for this debt, they are still to be treated as a borrower. Now, the surviving spouse, the successor in interest, may ultimately choose to assume the loan, but that's going to be a separate consideration from them being treated as a borrower under RESPA or under TILA following these rules. So again, they will need to be considered for a loan modification oftentimes. There's some clear guidance if it's a loan that is insured by the FHA, the VA, or it's a Fannie Mae or Freddie Mac loan. There's very clear guidance in those servicing regulations that a modification and assumption should be considered simultaneously. If it's a privately held mortgage, you'll look to sort of industry standards as to what's reasonable, but certainly looking to those GSE or government-sponsored loans, the requirements that are written out in the regs are for consideration simultaneously of an assumption and a modification, which makes good sense. A borrower is not necessarily going to want to assume an existing loan without knowing the terms or being able to afford those terms. So again, a new and emerging area, one that we anticipate seeing some more litigation around, and certainly here in West Virginia, where we anticipate growing elderly population and leaving. This also would apply, I should say, to children who would inherit from a parent. That's one of the transfers that's also considered. So happy to talk further with anybody, and thanks for having me.